on what turned out to be a more quiet than usual night. In the bustling area just behind Greek Row, a 7-year bubble of tranquility was violently burst.
Tragedy at the University of Idaho, a day after 4 students were found dead in a home just steps away from campus.
It's been 5 days since 4 University of Idaho students were found dead inside their home just off campus. And we know there were 2 other roommates in the home at the time of the murders. And when police got there, they were not hurt. And police say they are cooperating. Moscow police wouldn't go so far, though, as to call them witnesses. And yesterday, the coroner's office released the autopsies and found all 4 were stabbed to death with a knife early Sunday morning. Police have not found a suspect or suspects and don't have any people of interest right now.
Who was targeted? If it was multiple people, it would go a long ways to telling the public what you're looking for, who you're looking for, the type of person you're looking for. Why not do that to alleviate some of the fears out there in the community? Don't you want more information from the public?
We do want more information, but we don't want to be honest, you're going to have to trust us on that at this point, because we're not going to release why we think that.
The handling of the case, shrouded in secrecy, did little to dispel the growing horror.
Problems at the campus, maybe talk of a stalker. There's been talk that maybe Kaylee had a stalker.
Kaylee was an absolute beautiful, beautiful girl. It wouldn't surprise me if all of these beautiful kids that we lost had stalkers, okay? That wouldn't surprise me. I don't think that that's what it was, though. I will be honest with you. I think it's closer than that. I think it's deeper than that. I think I think they have information that they're not giving us, and it's real fishy.
When you say you think it goes deeper than that, what do you mean?
I mean, I think it was somebody closer than a stalker, and I don't know who. I'm not gonna specify anything like that. I'm just going to say I think that it was somebody, and I think possibly they may have trusted. That's the only thing I can think of, because how could something like this happen so quickly, so quietly, so without any answer, unless it was somebody super close to them? You know what I mean?
Do you think the person who did this had been in that house before?
I think they knew them. I think they may have even been friends with them. I think it had to have been somebody close to them. To have been able to get away with it like this, without, it just doesn't make sense. None of this makes any sense. It had to have been somebody they trusted that was, you know what I mean?
As a mother, I feel like they know him. I do. I've always felt that way. Nobody has told me that anyway. I just feel it. Yeah. I mean, this is a college town. It's a small town. I feel the girls knew this person.
But we don't know that.
Oh, yeah. We absolutely don't know that. I just feel it in my heart that they knew the person. And I've always felt that way. I don't know why, but I've always said they knew him. Yeah. I just don't feel like this was like some rando just driving through Moscow, happened to stop by their house.
Well, John, there's a couple of things that I think are really troubling here. One, of course, is the lack of detail. Now, you would never expect any police agency to share all of the details of a crime of this nature with the public, but you would expect them to tell you some of the basics about how they're doing and what they're thinking, simply to calm fears, to let folks know that they're on the job and they're getting things done. Not only have they not done that, they've actually made statements that are contradictory and caused more confusion than they've helped. So how quickly they ruled out a fairly large group of folks who seem to have played key roles in the discovery of this crime. So you have the 2 roommates who were on the premises when the murders were taking place. You have some number of either a friend or some friends who came over to see those roommates the next morning before the 911 call was made. You have the individual who drove the 2 females from the food trucks back to their house right before the homicides took place. And all of those folks have been kind of dismissed as having no involvement. It just seems kind of quick to be writing off folks who were so close to this event. You'd think you'd want to do a pretty substantial, thorough investigation of each one of those people and their networks to ensure that there's absolutely no connection before you go out to the public and say, yeah, we've cleared all these people. But, again, I don't know what's going on behind the scenes.
During the critical hour of the murder, there were 12 figures of interest. This includes an unmarked Moscow police unit with 2 officers inside, who stopped 4 suspects. Additionally, 4 individuals were caught running in the background of Axon body camera footage. Completing the count, there were 2 surviving roommates from the incident. Thus, including the 2 police officers, there were a total of 12 key figures present in the vicinity during that crucial time frame.
Eager for answers. Well, now we're not going to be getting much, or if any, of those answers from anyone involved with the case. Just a few hours ago, a magistrate judge in Latah County issued a gag order preventing anyone, investigators, law enforcement, attorneys, or agents of any attorneys, from talking about this case publicly.
It's new, we're not used to the national attention quite this big. So I take responsibility for information not getting out as fast as possible. I probably should have been much quicker on that, but in the beginning of these, we're a small department, so everybody's working on this case, and to me to be included. But we realized pretty quickly that we needed to get information out. That's why we called in the PIO team.
The investigators' choice to utilize an internal team for interviews, rather than engaging with the media, is portrayed as a strategic decision aimed at aiding the investigation. They present this approach as though it's about efficiently disseminating information, rather than a tactic to avoid tough media scrutiny.
I've always seen our house. Dana was a good friend before, Ethan came up. But that's all I really want to talk about right now because I actually have class here in like 15 minutes.
Sigma Chi President Reed Othram says the fraternity is cooperating with the investigation. The fraternity is about half a block from the house where the murders happened.
Does anyone know where they were during that timeline? Like there's still this big chunk where...
as of right now, we've told Moscow PD, Idaho State Police, and the FBI all we know. We're kind of leaving it up to them to piece it together. Obviously, we don't have the utilities or resources to do it on our own, so we're just putting full faith in the officers and the detectives doing it. But that's all I'm doing right now.
Are there any cameras around?
No.
You said Dana was a friend and Ethan was like a member of the house? Mm-hmm. Okay, got it.
And what was your name again?
Reed.
Reed what?
Othram.
How do you spell that?
OFSTHUN.
When I went up there, I saw her just, a week before that. She changed a lot. She had a life. She got to see what it was to have a boyfriend to live with and have a real life. And she really turned around and was being really responsible.
All right, guys, we have 3 new motions in the House. Let's start with the objection for venue change. The state argues that the defendant's motion to change venue is premature, implying that it's been filed too early in the legal process and that there aren't sufficient grounds for that. It also cites a lack of adequate information, stating that defense attorneys had not provided enough information to prove that a fair trial or impartial jury cannot be found in Latah County. It specifically requests that the court issue the trial date and additional tasks pertaining to that, establish a briefing schedule for the defendant's motion, and schedule a hearing date. They also request deadlines for submission on all supporting documents pertaining to the venue change, blah, blah. Then the document goes on to name some criteria for the venue change. All right, blah, blah, blah. We took a new turn in the case. Defense got their experts. Now, a motion that was filed by defense attorneys for Kohberger requests clarification of the sealed order for disclosure of investigative genealogy information. It focuses on a stipulation within the sealed order that prohibits defense or any of its agents from contacting individuals identified on the family tree without prior court authorization. The stipulation is based on demonstrating the necessity and materiality of such contact if the defense chooses to ask for that. Well, Kohberger's defense points out that individuals identified through the protected IgG materials also inadvertently could restrict them from their ability to engage with these same witnesses or resources without the IgG paperwork. That's probably a terrible way to explain that. Okay, so what she's saying is, like, I'm already in contact with these people. Obviously, if it's just like a normal aunt, sister, whoever, she's already in contact with these witnesses. She's already doing mitigating defense work with these witnesses. And then now she finally gets the IgG turned over, looks at that seal, and there's something stating she needed to implicitly ask to have contact with people she's already had contact with, or is simultaneously, continuously having contact with. Did that make sense? So defense was ordered to not have any contact with anyone on this tree without implicitly getting the permission of the court first. And in essence, Kohberger's attorneys want them to specify that these restrictions pertaining to contacting individuals listed in the family tree apply solely to those that were identified to them, defense attorneys, from that tree and on that tree only. In response, the state says that the defense attorneys are free to hit up whoever they want as long as it was some other lead that led them to that witness. And I'm like, so are they supposed to be able to provide how they got to that person that wasn't IgG? Doesn't that just, I don't know. It doesn't make any sense. Not to mention the fact that if they really wanted to, they could perform their own family tree and essentially, hopefully, wind up with a pool of similar suspects in theory. But of course, it would take a lot longer and it'd be all against that whole, attorneys are supposed to disclose things to one another because they're supposed to perform above board investigations. Go figure. I digress again. Okay. All right, this next part is weird. Prosecutors point out that the purpose of these experts or investigators going through the IgG information is to understand what led the state to Kohberger. Well, prosecutors allege that through the TUI letter that is used in order to request the information from the FBI. So if the FBI specifically, however I said that. So if it's not the feds charging you, this is the way that a state or city municipal court would garner information from outside federal agencies that help them build a case on you. It is a way to mitigate all of the different courts being able to utilize federal agents and federal information pertaining to their disclosure guidelines and to easily access that testimony and that actual agent in court. A TUI letter. Okay, so prosecutors say that in that letter, defense attorneys for Kohberger should have everything they need, and they're so nice. They do allow any nameless agent so long as they actually want to bring their name forward, because prosecutors say that's the least they can do if they want to review that TUI letter as though she needs them to review it, right? Because she would totally have to hire an outside agent in order to understand a letter. But it's kind of insane. It literally makes me want to bang my head against the wall how little sense that makes. So the prosecuting attorney is telling defense attorneys that they can find the probable cause that was gathered in order to arrest their client, the defense's client, in the letter that went back and forth between prosecution and the FBI, not in the probable cause warrant. Oh, wait. They specifically left IgG out of the probable cause warrant. That part. So without even explaining it, I'm going to go ahead and predict that eventually this is going to lodge a motion to suppress the STR evidence in court. You can't get to the STR without that IgG work. You just can't. And it's kind of blatant, not even kind of, it's blatantly weird that prosecuting attorneys try to leave that out. It's just like this weird, there's so much wiggle room throughout the PCA and the evidence that's been presented so far being entirely interdependent, meaning without one, you can't have the other. It's like married with children in this bitch, because Department of Justice specifies that you need to have some other substantive piece of evidence other than the forensic genealogy leads. So there needs to be something else to corroborate guilt other than the forensic leads. Otherwise, we'd just be leaving federal agents surreptitiously stealing everyone's DNA, possibly planning it. I mean, it would just, in my opinion, lead to a bunch of chaos, and I mean, obviously to a lot of people at the DOJ. And that's why this interim order came about. So they're not actually supposed to surreptitiously take DNA from Kohberger's dad for comparison. They can, but they're technically supposed to ask him, and he's supposed to give a type of informed consent in order to go that route to obtain a comparison. So the fact that they could not match their alleged genetic material from the knife sheath button, as they claim, to this defendant without doing forensic genealogy work, and then ding, 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 what do we not have for them, Johnny? Because they can't have this 2015 Hyundai Elantra as their alleged suspect vehicle 1, because suspect vehicle 1 is a 13, or backwards to 2011. And the 2015 had a noticeable facelift. I mean, it's very blatant to any layman. You do not have to be a special agent to see the blatant difference in the facelifted version. There's practically indications all around the car, like all the way around it, on the sides, the trunks, the lights. There's no way that they should have confused this car with a 2011, and there's certainly no way that they should have been able to reverse engineer it and be like, oh, hey, it's March 2023. Special agent such and such decided it totally could have been BK's car. Okay, pretty exciting story, right? Moral of that big long hoopla was that all they have is interdependent evidence. And as defense attorneys for Kohberger pointed out, you can read it over and over and over again. There is no clear connection that establishes probable cause within the Department of Justice, Idaho State Police guidelines pertaining to their contract with Othram, and forensic profile collabing that they do together or outside of each other. So not only that, but it did end up coming down to that big gauntlet I had been telling you guys about. I knew it. I knew that they had uploaded him as a John Doe. And this was brought up whenever defense put experts on the stand that were like, yo, you should have a receipt if you did this through law enforcement portals, because it costs money and therefore it renders a receipt. B, Department of Justice suggests that this is a part of the bare minimum that you're going to be turning over to defense. So they should have obtained a receipt for that. But lo and behold, after all of those months actually fighting and not wanting defense attorneys to even know what private lab had Bryan Kohberger's genetic material to work on or to generate leads with, they didn't even want them to know where that was. But then finally, boom, it all comes out one day, and then a motion asking the court to protect the IgG information and protect those who had uploaded their DNA into regular user databases. So the state was asking Judge John Judge to consider everyone who has put their DNA in 23andMe, Ancestry.com, MyHeritage. All of them are to be considered informants in the request that prosecuting attorney asked the judge for. It's crazy, okay? And then they basically get it. But I'll say the judge hopefully recognized how legally absurd that would have been for him to call people who didn't even know they were actually contributing to the databases that law enforcement were illegally searching, but that they could also be simultaneously not knowing that and also informants for the state. What the? Right. So instead of that, they get a in-camera hearing that only has prosecuting attorney and the judge himself there, and it didn't even seem like Anne was going to get the inventory that she wanted, which was just a log of all of the information that they discussed, divulged, and made the judge aware of during that in-camera hearing. And Bill Thompson was particularly miffed when she asked for it too. He's like, I don't understand what this log is that she wants. So that I have to blah, 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 blah. To me, the whole point of this is to keep that bitch out of my business. Like, you remember though the part where it's not your business, bro, and you're not the one going to jail though? That part. But they did get their way as far as it was pertaining to that. Now, one thing that I want everyone to understand is this John Doe profile that they uploaded into a personal database, because I saw a lot of people conjecturing that Anne, in her endeavor to contact all of these witnesses, was essentially going to be making a list of which relatives had opted into law enforcement and which relatives had opted out. But there is no opt-in, opt-out, because they used a public database. So there's like literally no option for that user to prevent law enforcement from viewing it, because they are breaking the Department of Justice guidelines and essentially skirting the whole like ethical basis for having these guidelines in the first place. Hold on, I'm finna go bang my head. Okay, I'm back. Kind of hurt. Just kidding, guys. I didn't bang my head. I might though. I'm finna. Okay, so I say so too much, huh? I know if I'm getting on my nerves, I'm getting on y'all's nerves. My bad. Okay, so, see?
The Idaho State Police partnered with a renowned private lab to delve into complex DNA evidence found on a knife sheath, using investigative genetic genealogy. The project began with the lab developing a SNP profile and starting a genetic family tree. However, the analysis was shifted to the Federal Bureau of Investigation, leading the private lab to stop its work and send the SNP profile to the agency. Defense attorneys argue this move to the Federal Bureau of Investigation, away from an impartial lab, shows clear prejudice and bias, indicating the agency already had a target in mind.
Takes it out of this kit, turns it into an SNP profile, and as soon as they are just chugging along, here comes the FBI like, you know what, scratch that. We got this. And defense attorneys had already highlighted that this was them targeting Kohberger, because why would you take it out of the hands of a third-party agency that was actually going to be generating leads, like real genetic leads, versus already knowing who you want to point your finger at and being able to manipulate the results there too? Okay, so what else? Definitely wanted to let everyone know about the John Doe thing. Had nothing to do with opting out. Oh, the venue change. Okay, so I constantly see people say, you know, there can still be a pool in Moscow that might not be prejudiced to Kohberger. I do not agree with that statement. I think it's a bit absurd. And, you know, if I'm being honest, I emphatically believe that those who do not want him to get a trial elsewhere are inherently biased and unable to override those biases, because, you know, if you really believed in a fair trial or in a fair procedure and process that doesn't violate someone's due process rights, that doesn't violate someone's constitutional rights, you would allow it to move there on default, especially when you have a prosecuting attorney who's like, we cannot do this except for the summertime. What? Nope. The summer. Okay. You guys want summer? Cool. I guess summer works for us, but there's no other time that we can do it ever unless it's summer. I mean, and then he legitimately quotes the town, the people, the high school, and the students at U of I. He never once, unless you count when he ends it with, it's not fair for anybody, but he says, not fair for our students. It's not fair for our citizens. Like, he literally named everyone but the defendant on the other side of the courtroom when he talked about a fair trial. It's absurd. And even the judge was like, well, we're not supposed to be arguing venue today, because everything that they're there for a scheduling, but everything that Bill Thompson was saying pertained to venue, because all of the reasons he was alleging they couldn't allow BK a trial whenever his attorneys are ready to go. was because of the schools and because they have to do it during the summertime. So even the judge was like, well, you seem to be arguing about venue, even though we're not arguing about that today, which in my opinion can be fairly interpreted to say like that's his low-key way of being like, all that shit can be solved with a change of venue. Excuse my language. And it's hard enough to even like perceive the idea that you might get 12 good jurors. We're actually typically only having an outlook that's like 6, right? We want 6. We want 6 of them that we can depend will look at our side objectively. But everyone only ever brings up juries during the conversation of like whether the venue is right or not, which is seriously like oversimplifying all of the things that can actually mount to create an unfair trial. Hold on, I'm gonna go bang my head again because Julie Fry is the court clerk who's filing this change of venue motion. That's Chief Fry's wife, yeah. Kathy, the coroner, was serving her dual purpose because she is a Latah County public defender. And I mean, it blows my mind that they have a county coroner doubling as not just a private defense attorney, which to me is a clear conflict as well, but it doesn't get much more conflicting whenever you combine the county coroner with a public defender. I'm going to go bang my head some more. This case, you guys. But emphatically, the clearest way for a judge, any authority, anyone in the legal profession to demonstrate impartiality, especially amid concerns of trial fairness, is by taking every possible step to ensure and openly communicate efforts towards an impartial proceeding. And even in the shadow of doubt, I mean, if there's an inkling to you that I am biased, that I am unable to overlook my own inherent biases in order to give you that fair trial, if you don't think that I'm going to, let's say that I believe I totally can, but you think that I can't, are you getting a fair trial if technically you think that I'm unable to do that? I mean, is that possible? So there's a lot of nuance with arguing fairness in trial, but the clearest way out of it is to recuse, change venue, insert solution here, because if someone even perceives you to have a bias, it could be argued that it did infringe their rights. But unfortunately, a lot of people who are truly biased, and especially when it comes to like judges and people in these positions where it's hard to remove them unless they decide to recuse themselves. But unfortunately, what this leaves us is with judges who are actually agreeing to this are probably or possibly actually not biased. So you have the problem where the biased ones are hanging on to the case for dear life, and the ones you were paranoid about and asking to recuse themselves or otherwise be replaced, and you might actually be risking, replacing someone who was irreplaceable. Oops. Damn, I irreplaced my juror again. Have y'all seen my juror? What'd I do? Damn it.